Thank you. Mr. McGinty,
Yes,
City
Mayor.
Attorney's report.
Yes, Mayor, I have just one item to report, and I'm happy to report that we have received a final decision in order from the State Historic District Commission in the case of Phil Belfie versus the City of East Lansing. As you know, City Council applied for a certificate, a notice to proceed to allow the demolition of 4 city-owned properties on Evergreen Avenue. That decision was appealed by Mr. Belfie to the State Historic Review Board on April 13th, 2009. And the Administrative Law Judge, Andre Friedless, issued a proposal for decision on August 26th, basically proposing and finding that Mr. Belfie had no legal basis for bringing that appeal, that he both lacked standing as asserted by the city, and he also had brought the appeal in a quite untimely manner, contrary to the state historic preservation statute. And so Judge Friedless proposed that the appeal be dismissed, and he also, in his findings, made a finding that the one substantive basis of Mr. Belfie's appeal, specifically that the city lacked legal authority to apply for such a permit since it didn't own the property, or not all the property at least, was without merit, and that there were no other challenges. And so on the substance of the appeal, he likewise found for the city.
Comments from Mr. McGinty? I guess I would receive that the integrity of our process has been challenged, has withstood the challenge, and is intact. Is that a fair statement?
It is fair. The challenge was both that the city had no legal basis to apply for the demolition permit, and that the Historic District Commission had no jurisdiction or legal authority to hear the application. And both of those challenges were, that was the substance of the appeal filed, and both of those challenges were found by Judge Friedless to be without merit.
Okay.
Mayor and Council, on September 15th, 2009, I reported to the Council on a favorable outcome in the case of Phil Belfie versus East Lansing Historic District Commission. Yesterday, I read a guest editorial in the local print media in which Mr. Belfie claimed that I misrepresented the outcome of that case to Council, that I misinterpreted the decision and simply lied to Council. I want to assure Council that that accusation is absolutely false, and I'd like to set the record straight. In that decision, the board granted our motions to dismiss for lack of standing and lack of timeliness. When I reported on that decision on September 15th at the last regular meeting, I guess, I explained that the decision was to dismiss based on lack of standing and on timeliness. But I also said that the decision had also, or the opinion had also ruled on the substantive issues in the case as well, and that we had prevailed on the substantive or heart of the matter as well. That second comment I made to Council is what Mr. Belfie claims is a lie or a misrepresentation or a misinterpretation of the opinion. That is simply not true. I'd like to pass out the judge's opinion, and I've given you just page 4. But I can assure Council that I did not misconstrue, misinterpret, or mislead the Council on the outcome. And I will put these comments in writing to the Council later this week. Thank you.
Okay, thank you, Mr. McGinty, and thank you for this document as well. Did you have anything else this evening?
No, thank you, Your Honor, no.
Okay.
Hello. I want to briefly discuss two documents that were mentioned by Mr. McGinty. One being the letter that he was said he would submit to the council, and the other, of course, is Judge Friedlis's finding in the case of the demolition of those homes in Evergreen. So we can use this time to talk a little bit about page 4. He says, that is, Mr. McGinty presumably says, the opinion concludes on page 4 as follows, and then he repeats that list of those entities that can indeed file applications. Now the judge was talking about that particular issue because only those people who are applicants have the right to appeal the decision of the Historic District Commission. So in this particular case, what that means is that those people who owned those properties did not have the right to appeal the notice to proceed with the demolition of their own homes. So I would like to just spend the last few minutes here going over that page 5 very briefly. It's essentially just one paragraph that is of importance. It is that one paragraph that concludes that issue. In other words, do I have standing or don't I? But here's what he said, and this is the last paragraph of that section. I'll read it in its entirety. Petitioner's August 12, 2009 brief asserts that the City of East Lansing had no standing to file the request for demolition. But that is not an issue before me. Respondent accepted the city's petition and decided in the city's favor. The issue before me is whether petitioner may appeal this decision, not who can file a petition with respondent. Now in the document that I'm reading here, the judge is finding, that last sentence, the word not is underlined. The judge is making very clear that he is not ruling on what Mr. McGinty calls the substantive issue. He is not. In fact, at the beginning of the paragraph, again repeating myself, he says, but that is not an issue before me. Now, Mr. McGinty accused me of not having a very good grasp of legal matters, and perhaps that's true. I'm not a lawyer. But I can understand English. And when the judge says that is not an issue before me, well, I think that's very, very clear language. And why Mr. McGinty refuses to accept that language and that ruling is just beyond comprehension as far as I'm concerned. They won their case. Nobody appealed the decision. Nobody could appeal the decision. They won their case. And I can't understand why you would go about lying about it. And the judge dismissed my appeal because I didn't have standing. That's the end of it. But the documents that I referred to here are available on publicresponse.com. I urge you to go there and read them for yourself and see whether or not the judge has made his decision in a clear manner, presented it in a clear manner, and then ask yourself the question, why would Mr. McGinty mislead the council and, of course, the public, that is you and I, on that case?
I think it can't be any clearer based on the judge's plain language that I did not misinterpret, did not mislead, and did not lie to the council. I would never do that, and I did not do that in this case.